Good evening, ladies and gentlemen. I'd like to welcome you to the regularly scheduled meeting of the Municipality of Thames Centre Council. The date is September the 9th, 2024. We're located in the municipal office at 4304 Hamilton Road in the village of Dorchester. It's 5 p.m. and I'd like to call this meeting to order. I am not aware of any additions to the agenda. So may I have a mover and a seconder to approve the agenda as circulated. Councillor Lockie, seconded by Councillor Crockett. All in favor? Thank you. Motion carries. Any disclosure of pecuniary interest or the nature thereof from members of council? Seeing none, we'll move on. Announcements. I have an announcement tonight that I'd like to send out a huge congratulations to all the staff members, the members of council, and anybody else who was involved in the weekend putting on the first ever Corn Fest. It was a great event. Too bad the weather didn't cooperate, but we had some fun and we dodged a lot of raindrops. But beyond that, it was really good. Nice to see so many people around, particularly in the in the morning hours. Sure hope you can do better with the weather next year, group, but beyond that, everything was great. So thank you. All right, so item number 6 on your agenda is the planning portions. At this point, I'd ask that council adjourn its regular meeting at 5:02 p.m. and move in to public meeting pursuant to the Planning Act to consider an application listed on the September 9th, 2024 council agenda. A mover and a seconder, please. Deputy Mayor Smybert and Councillor Crockett, all in favor? That carries. Okay. Item number 6, a zoning bylaw amendment application Z6-24 for 1008-51297 Ontario Inc. in care of Brandy Poles, applicant for property at 15 Jane Street. So Ms. Cortez, whenever you're ready.
Thank you, Your Worship, through you. So the purpose and effect of this application is to rezone the subject property from the office residential OR zone to a site-specific office residential zone to permit a personal service establishment and a clinic as additional permitted uses on the property, which is otherwise not permitted under the current zoning. And also a reduced number of parking stalls is also being requested. So the subject property is situated on the west side of Jane Street, north of Hamilton Road, County Road 29, and the lands are zoned office residential within the zoning bylaw and are also located within the general commercial designation. The lands are also identified to be within a core area according to the Thames Centre official plan. So the property contains a 93.6 square meter concrete and steel building, and the property is serviced by municipal piped water and a private septic system. The applicant is proposing to establish a medical aesthetics business, which would operate out of the existing building. So in addition to the personal establishment use, the applicant is also requesting to permit a clinic to ensure that there would be no zoning compliance concerns in relation to operating a medical aesthetics business on the property. And it's intended that the business would have 3 employees and anticipate having up to 6 clients at a time. So the zoning bylaw requires that a personal service establishment shall have 1 parking stall per 15 square meters of building used for the business, including 1 accessible parking stall. So in this case, for a personal service establishment, 7 parking stalls, including 1 accessible parking stall would be required. And for a clinic, 5 parking stalls, including 1 accessible parking stall would be required. So staff have determined 2 standard parking stalls or 1 accessible parking stall would meet the requirements of the zoning bylaw and could be accommodated on the property. The provincial policy statement, County of Middlesex and municipal official plans all encourage a mix of land uses and settlement areas, including commercial uses. And the official plan states the function of core areas as commercial and community centers must be maintained and enhanced through effective design standards, revitalization policies, and the siting of appropriate commercial uses within and outside of such areas. The official plan also notes the municipality has the ability to allow owners to make payment in lieu of parking spaces, and that the municipality can collect money which can be used to provide municipal parking within the area. According to the official plan, several factors must be assessed when determining if a site is suitable for payment in lieu, such as the impact the number of required parking spaces may have on the development's feasibility and the cumulative effect of applying the payment in lieu policy. So currently, the municipality has not implemented this type of policy, and there have been few requests for reduced parking in the commercial core. As a result, staff believes that requiring cash in lieu of parking would not be appropriate without the establishment of a municipal parking fund policy. And given the availability of on-street parking near the property on both sides of Hamilton Road, staff believes that a reduction in parking stalls is appropriate. The official plan indicates exemptions for payment in lieu of parking will only be applied if the municipality is satisfied that parking on site is not necessary and that the municipality can supply sufficient parking within a reasonable distance from the site. Thames Center's official plan also contains criteria used to evaluate zoning bylaw amendments. Staff is satisfied that the criteria has been met or is capable of being met during the building permit stage. Unacceptable adverse effects on surrounding uses are not anticipated considering the range of uses permitted as of right under the current zoning. The applicant has advised that signage to indicate parking is to occur on site or by using on-street parking on Hamilton Road will be placed on the property. Given the property is located within a commercial core area and on-street parking along Hamilton Road is available, staff is of the opinion that the proposed use, including a reduced minimum parking requirement of 2 standard stalls or 1 accessible stall, would be appropriate. In regards to the request to permit a clinic in addition to the personal service establishment and reduce parking, Section 3417 of the Planning Act states that where a change is made in a proposed bylaw after the holding of a public meeting, council shall determine whether any further notice is to be given in respect to the proposed bylaw. And staff believes the proposed clinic use would be similar to the proposed personal service establishment use, and therefore is of the opinion that further notice should not be required. Based on the foregoing, staff is of the opinion the subject proposal is consistent with the provincial policy statement and conforms to both the county and Thames Center official plans. In regards to staff and agency comments received during circulation, comments were received from the county engineer, drainage superintendent, chief building official, bylaw enforcement, and the director of public works, and these comments are attached to the report. Comments were also received from the Upper Thames River Conservation Authority, who have advised no objections for the application. In regards to public comments, comments were received from Andrew McClure and Stephanie Meyer, and these comments are also attached to the report. Staff recommends that application Z6-24 be approved and that no further notice be required pursuant to Section 3417 of the Planning Act regarding rezoning the subject lands to allow the clinic, and that the implementing bylaw be approved as included in the bylaw portion of the agenda. Thank you.
Thank you, Ms. Curtet. Does the applicant want to provide any more? Oh, I'm sorry.
Yes, Your Worship. I'm bringing in Dan Smith, who is the
Okay.
agent.
Go ahead.
Hi, Dan. Can you hear us? Hi, Mr. Smith. Can you hear us okay?
Yes. Yes, Your Worship. I can hear you folks. Can you hear me on audio?
Yes, we can. You can go ahead whenever you're ready.
Thank you, Your Worship, and good evening, members of council. Dan Smith. I'm representing Finlater and Associates on behalf of Brandy Pool's application. I just wanted to state to council that we have had the opportunity to review both the application itself and the report from the municipal planner. And we are certainly in agreement with the comments that have been made. And we are here to support the application and believe that it makes sense on the ground and is certainly represents good planning. Thank you.
Thanks very much, Mr. Smith. Any questions from members of the public, either online or in chambers?
No one online, your worship.
Okay. All right, then I will turn it over to council. Oh, I'm sorry. Do you want to come forward, state your name, your address, please?
Marcel Meyer, 9 Jane Street. So while I welcome a new business to our community, I can't help but at least bring comments forward to council of caution because of this postage stamp parcel of land has concerns in my mind. While I appreciate the planner's comments of why 2 normal parking spots may be sufficient, I really question whether going from 7 parking spots to 2 is a minor adjustment. So parking to me is a concern. To add to that, being that those vehicles will be backing out onto a very busy street, cause right at an intersection, a very busy intersection, that does to me cause some concern for having this location be changed for this reason. Additionally, if I'm not mistaken, and nowhere in the information is this documented, but unless I have bad information from way back in time, that property shares a wastewater system with its neighbor. And with the increased use that this change in use is going to bring to the property, my question to staff and council is what happens when there's a failure? Because of this decision is not temporary, it's forever. And how do they address that? Because once the zoning's in place, how do you change it? And with a shared wastewater system compared to if a new business was being built where you would not only need a fully contained wastewater system, but a contingency area, what will they do in this case? And so I really think there should be consideration for that before this is given. Thank you.
Thanks, Mr. Meyer. At this time, is there any comment from staff regarding Mr. Meyer's concerns?
Through your worship. So as part of the building permit process, the adequacy of the septic system would need to be demonstrated. And if should it not be adequate, I guess at that point, it'll be dealt with or a building permit won't be issued. Thank you.
All right. Any other comments regarding this? No. In the meantime, okay, we have someone else who would like to speak. Your name, please, and your address.
Andrew McClure.
Okay.
My wife and I own the salon next door. We already have issues with parking. It's really hard to get in and out of that lot. I can attest to that. I always park on Hamilton Road to help ease clients in and out of the parking spaces. And I'm often quite down the street, trying to get up to the corner with 6 people plus 2 staff members. That's a lot to ask on that area of additional vehicles. I foresee it being an issue, and there won't be a lot that I can really do about it when it is.
Thank you, Mr. McClure. Anyone else? Do we have anybody online, Sarah? Who,
No, your
are
worship.
interested? All right. Then at this point, I'll turn it over to council for questions or comments. Councillor Crockett.
Oops. Can I move this? Is it going to be fine? Okay. Thank you, your worship. I just want to state that I think parking comes forward often, considering that here in Dorchester, particularly, we don't necessarily have a downtown core. So parking is a difficulty throughout. Luckily, this establishment is adjacent to Hamilton Road where there is parking spaces. understanding that this is a busy intersection, I think will be something that the owner will be cognizant of in communications in speaking with them ahead of this meeting. In addition to that, this establishment was previously a salon. I'll bet it was during a time when that road was a dead-end street. So I think bringing in a business similarly to that will be successful, and hope to continue along with For the Look and other businesses along that intersection, I guess, to help kind of build us a bit more of a downtown and have people enjoying the surrounding businesses while they're out here. So I just wanted to mention that. Thank you.
Thank you, Councillor Crockett. Is there anyone else? Councillor Lockie.
Through your worship, I do share the concerns of Mr. Meyer regarding the parking. Going from 7 spots to 2, and Hamilton Road can already be really busy for parking, especially if there's a funeral. So I don't support this application for that reason.
Thank you, Councillor Lockie. Deputy Mayor Smyber.
Thank you. I'm not sure who to address this question to. I do understand that we don't have a municipal parking fund policy at this point in time. But when would we be taking a look at that? I mean, I think we'd want to start earlier rather than later to build up that fund. And I just wanted to know from staff's opinion, kind of when we can see that happen.
CAO Bear.
Thank you, Mayor. Through to the Deputy Mayor. It's something that we have been talking about internally in the mix of reviewing and updating a lot of our other policies. So certainly with the conversation today, we can prioritize it. Thank you.
Are there any other questions from the members of council? Councillor Heeman.
So am I correct in assuming that this application would not be captured by a revision to the policy for parking in lieu?
Dan, you were, okay, Mr. Fitzgerald.
Yes, just through the chair to members of council. So because you don't have an actual physical bylaw in place right now, planning staff wouldn't be able to recommend a cash in lieu parking type situation where you would offset parking requirements based on the need or establishment of municipal spaces. So the intent of a cash in lieu parking bylaw is physically to have someone offset the cost for the municipality to establish that stall elsewhere. So very common, especially within, traditional downtown areas that, over time, these types of uses didn't require many parking stalls. Now we're very vehicle centric. We have everyone traveling everywhere. Our lots are very small in our urban cores, and we run into these situations quite often. So while I would say, technically speaking, and Alana and I did go back quite and forth on this particular application and the parking requirements that are kind of based on the bylaw. We did get a plan from the applicant that shows 5 stalls on the space or on the site. That's in tandem, so meaning cars parked one in front of the other. It's just an unfortunate situation that from the bylaws perspective, we cannot consider that as parking stalls physically by the way that the bylaw requires how stalls, the length of them and how you get out and egress and things like that, right? So when we say 2 stalls, we say 2 municipally approved parking stalls. In reality, it's likely that the owner and employees can still physically park on site. So while we say 2, that's what the public stalls would be. But it's more likely that they can fit additional parking for staff members on site.
Thank you, Mr. Fitzgerald. Are there any other questions from the members of council? I have a couple. One is that, Mr. Smith, are you still online?
I am, your worship, yes.
I'd like to ask, would the applicant be putting up any sort of signage that would indicate where customers could park?
Yes, your worship, it is my understanding that the applicant's quite prepared to do so and also advise her clients through some of her promotional materials of the parking situation ahead of time. That's my understanding.
All right, thank you. Is the applicant in the room? Yes. Do you have anything to add on that? Do you want to come forward, please? And just state your name for the record.
Thank you, your worship and council. I'm fighting laryngitis. So sorry. Bad timing.
That's okay.
I just wanted to add, the business that was in there prior to me had 6 large workspaces. So it was very outright. 6 individual people were working at desks at any given time in that space. I'm not sure where they parked, but that really, to me, speaks to that there really won't be a whole lot more people in the building now with my purpose there than there was previous. I don't know how the parking was then. I didn't use any services in that building prior to there, but I am thinking that there isn't really going to be coming and leaving any more than what shown to be the workspaces there already. And I am certainly able to and eager to alleviate the parking concerns by putting up signage that encourages no parking on neighboring properties, not just please, here is the parking on Hamilton Road, but also the neighboring properties are not appropriate. So I will be happy to do that as well.
Okay, thanks very much. I don't think that I have any other questions. So if there are none, Councillor Heeman?
Through you, your worship, to planning, is it possible to have that signage as a condition of approval? Because I know where we've had discussions of signage in the past, the signage was not forthcoming, and then that is in no way against any of the applicant today. It's just, I know we can prevent making the same mistake twice. That's probably a good thing.
Through your worship to Councillor Heeman, I'll direct that to Dan.
Yes, so through the chair to council, great question. Typically, if we're looking to do something like add a very specific requirement, we could add a site-specific provision in the zone that would say you have to add this certain thing in order to establish that use on the property. In this particular case, you could also go down the path of saying this is a use and intensification of the site. This would trigger site plan control. And through that process, you can actually establish that requirement to have signage on the site. You could establish things like shared parking considerations, street parking considerations. We could even go beyond that and consider cash in lieu, assuming that we had something to build off of through that site plan agreement. So that's probably the best way or best case scenario forward to ensure that signage, because through that process, you're actually going to get an agreement registered on title.
Thank you, Mr. Fitzgerald. Anything else from council? Okay, if there is no other, if there are no other comments or questions from council, the public meeting on this portion is now closed. And do I have a mover and a seconder on the recommended motion as appended to your agenda? You're moving the motion?
I'll move the motion. And
Okay.
I just wanted to point out, motion before us does instill the specification of the public parking stall. As well as there was mention in Delana's report regarding the promise for signage from the applicant.
All right, so we have a mover, a seconder, Councillor Heeman. All in favor? Any opposed? Motion carries. Okay, thank you very much. A mover and a seconder to adjourn the public meeting then, please. Deputy Mayor Smybert and Councillor Lockie, all in favor? Thank you, motion carries. The planning, I'm sorry, in the time on that one, then for the clerk is 5:24 p.m. The planning, the next part of the agenda is that the planning public meeting adjourned at 5:24 PM in order to sit as a committee of adjustment under the Planning Act to consider an application listed on the September 9th, 2024 council agenda. We've already voted on that, but I'll read it out. All right. So moving on to number 7, Committee of Adjustment, 7.1, minor variance, A8-24. 731607 Ontario Limited, John Fuller applicant, Stuart Finlater, Finlater and Associates, Inc. as the agent. Property address is 256 Hamilton Crescent, unit number 1. All right, I will turn this over to Ms. Cortez again. Thank you.
Thank you, Your Worship, through you. So the purpose and effect of this application is a request to seek relief from the Thames Center Comprehensive Zoning Bylaw as it relates to the placement of disused rail cars, also known as sea containers, which is otherwise prohibited throughout the municipality according to the zoning bylaw. So the subject property is situated on the east side of Hamilton Crescent between Newton Avenue and Marion Street in Dorchester. And the lands contain an existing one-story shop with a floor area of 1,952 square meters. And the property is used for industrial purposes in the form of a contractor's yard. So the applicants are proposing to construct a 335 square meter building to be used for industrial purposes and is proposing to incorporate sea containers as part of the structure, which is not permitted within the general industrial M1 zone or in general within the zoning bylaw. So to facilitate the new structure, an application for site plan control has been submitted to amend the existing site plan agreement, and the applicant is working with staff to advance the application. This minor variance application is required for zoning compliance as part of the site plan process. And the site plan control application amends the existing site plan that's registered on title, which facilitated the current development. So the variance was evaluated against the 4 tests of a minor variance, and staff is of the opinion that the variance meets all 4 tests, being that the variance is considered minor in nature, desirable for the appropriate use of land, maintains the general intent and purpose of the official plan, and also maintains the general intent and purpose of the zoning bylaw. So unacceptable adverse impacts on neighboring lands are not anticipated, given that the sea containers would be located in an industrial area, and considering the sea containers are to be incorporated as part of the building, the sea containers may be indistinguishable from the rest of the building. So in regards to comments received from staff and agencies, comments were received from the drainage superintendent and the director of public works, and they're included in the report. And then also comments were received from the chief building official, the county engineer, Upper Thames River Conservation Authority, and no concerns were identified as part of those comments. No public comments have been received to date. Staff recommend that the minor variance application be granted for the reasons outlined in the report. Thank you.
Thank you, Alana. Stuart is not in attendance. John, do you have any comments you wish to make? Certainly. If you just want to just state your name again for the record, please.
Oh, okay. Yes, is it on? Okay. Thank you, Your Worship, Deputy Mayor, councilors, administrative people. Thank you for letting me speak tonight on this issue. For those of you who don't know me, my name is John Fuller. I'm the applicant. I have lived in Thames Center my whole life, growing up in Thorndale, and then moved to Dorchester. I was a volunteer fireman in Thorndale growing up, and then started a business in 1982 in Dorchester, looking after the hydro system in the village for 40 years. I am currently a property owner on Hamilton Crescent, Marion Street, and Catherine Street. And in 2015, I applied for a site plan approval for a property on Marion Street, which was granted, and it took approximately 3 months to get approval for that. In March of 2022, I applied for a site plan approval on the property at 256 Hamilton Crescent. to be allowed to construct the same 5,000 square foot building that I had been granted permission for 7 years ago, 7 years prior to that. After going back and forth with the planning department and spending thousands of dollars on drawings, et cetera, like over $16,000 drawings, I downsized the building that was previously proposed. I hired a professional engineering company from Tilsonburg who specialize in building structures with shipping containers. After receiving comments back after my submission, after receiving comments back from the planner, it was noted that shipping containers are not permitted. In bylaw 4.30-15, if I can read it to you, it says, these are uses prohibited in all zones. It says the location the location or storage of any land for any purpose whatsoever as disused, any disused railway car or part thereof, street car or part thereof, truck body or part thereof, bus body or part thereof, whether or not the same is situated on a foundation. So that's what the bylaw reads. The comments I received back from the building services said, further to comments offered by the previous CBO, the proponent shall be advised that the location or storage of any purpose whatsoever of any disused railway cars, and then in brackets, a little section was added, shipping containers. That's not what the bylaw says. Bylaw has nothing to do with shipping containers. So it's a clause 4.3-15 of Thames Center zoning bylaw. So that's the two differences, or the differences that I received back. After receiving that information, I took a drive for about an hour and a half just south of where I live on Catherine Street. And I took pictures of 71 locations where shipping containers were placed in residential, industrial, and commercial properties. In 3 locations, the same type of building as I am proposing has been erected. These buildings all had building permits. Many of them were placed on concrete pads and are being rented out as commercial units. I would be willing to say that if I was to drive in the whole municipality, and I'm very confident of this, if I was to drive, I could find 200 shipping containers. You know, they're all over the place. I believe that there are being permits taken out and approved by previous building inspectors due to the fact that there is not a proper description or definition in the bylaw of what a shipping container is. A shipping container is not a disused train car. Because of this, I am asking you to consider the refund of the $1,200 fee that I paid for the minor variance. And also, the biggest thing is the extended waiting period. This is going on the 3rd winter now that I've tried to put up a building. And we're going to get into, the weather's going to change soon. And we're going to get into extended or extreme costs for concrete and everything like that. So I asked for a little bit of consideration on that. I guess that's all I have to say. Thank you very much.
Thanks, Mr. Fuller. Are there any questions from anyone in the chambers, publicly or online?
There's no one online, your worship.
Okay. All right. If that's the case, then I'll turn this over to questions or comments from the members of the committee. Any questions or comments? Councillor Heeman.
Thank you, your worship. Thank you, John, for outlining your situation and your difficulties getting to this point. Um, I'm pretty sure I was around when that bylaw was put into place. And if I can remember the intent correctly, it was to prevent people from just popping shipping containers in residential areas. And I think that the fact that you went through the effort to get an engineered set of drawings, I think that then looks at the shipping container as a building material, and therefore it's part of a newly engineered structure, because I don't think we want to prohibit access to shipping containers outright. I think we want to maintain the ability to regulate their uses so that the uses comply with existing planning regulations. Again, because these are highly mobile units, they can be put in overnight, and you know, I think that might have been how we got to 100 so quickly. And so I don't think we want to ban the use outright, but I think we want to have a reasonable process so that people are willing to enter or to work with us and be in compliance. So that said, again, because I think this is an unfortunate trial or trial or test of that bylaw, I would be in favor of refunding the $1,200 because I think this highlights a potential housekeeping item for us to review in future. Yeah, and again, like there's lots of uses of shipping containers. We just have to make sure they're in compliance, and again, tiny homes and things of that nature. Once they're used for a structure and the structure is permitted and engineered correctly, I don't see why we would not want to use it.
Thanks, Councillor Heyman. Is there anyone else who wants to comment or question on this one? Deputy Mayor Smybert.
And I appreciate Councillor Heeman's comments, and I just wanted to just ask staff, was that the intent? Is that the intent? And not that I'm questioning, I just want to make sure that we're really clear in terms of what the bylaw states, so that we know and then we can answer questions if we get any.
Sorry, through your worship to Councillor Smybert or Deputy Mayor Smybert. Is your question in regards to this potentially being a housekeeping amendment item, or?
Yeah, well,
the-
I'm hearing or I'm seeing that they're not prohibited. And then I'm hearing that, no, the intent is to allow them, but to regulate. So I just want to make really sure what the intent is.
So as of today, according to our zoning bylaw, they are not they're not permitted. We've taken the interpretation that the disused rail cars are sea containers. So as of right now, they're not permitted. However, sea containers within the municipality can certainly be explored as part of a housekeeping amendment in the future.
Sorry, Dan, go ahead.
Yeah, through the chair to members of the committee. So maybe I just add a little bit more to that. So typically when we review zoning bylaws, they're inclusive. So they tell you what you can do. So they define uses and they tell you what you can do. A shipping container is not a defined use in the bylaw. There's no general regulations that surround that. So our best bet is to look at other potential options to interpret what that means in terms of uses that come forward to us. So when we look at that section 4.30 that was pointed out, sub 15, so everyone keeps talking about rail cars, which is quite funny. It's not about the rail cars specifically. It says rail cars or parts thereof, trucks or truck bodies and parts thereof. So it's more open to the idea of capturing all of those things that become parts thereof of a rail car, of a truck body, and that specific item, I would argue, has been tested across the county legally and has stood up. So that's kind of where the planning interpretation comes from that. But I certainly totally appreciate that shipping containers in general, because we've seen it everywhere, is certainly, a very big budding issue today. Alana and I were talking about it with Amanda as well, and just saying it's probably an item that we would want to identify as a future updated bylaw consolidation or a staff amendment to say, let's provide additional clarity as to, maybe we want to support these things, maybe we don't want to support them, but if we do want to support them, how do we appropriately do so? And what are the areas that they're appropriately placed? So I think we need to have consideration for that moving forward.
Thanks, Mr. Fitzgerald. Is the applicant would like to comment?
Yes, thank you, Your Worship. I just wanted to say that of the three structures that are built in the municipality that did obtain building permits, the reason they received the building permits is because there was no clarification on what shipping containers were. They're not train cars. They're not truck bodies. It's not in the bylaw whatsoever, the shipping container. So the definition, there's no definition or anything like that to describe them. So I don't know, possibly going forward, there has to be something changed, but for right now, I don't think that they are noted in the bylaw.
Thanks, Mr. Fuller. That may be a conversation going forward. Any other questions from council before we move forward? Okay, so if there's no further discussion, the public meeting on this, oh, I'm sorry. I missed you. Sorry, Tom. Go ahead.
I just want to follow up on Mr. Fuller's request for waiving of the waiting period. Well, it was in request in two parts, and I don't think we can do that, but I wanted to seek clarification because that is a provincial requirement for variances. So I wanted to ask that question if there is any leeway, and then also just to speak to it so John didn't think we were ignoring him.
Is there comment from the planning staff then? Okay, go ahead.
Through your worship to Councillor Heeman. So as part of the Planning Act, we are required to, there is a requirement for a 20-day appeal period for a decision on a minor variance. So unfortunately, there would be no way to waive that. Thank you.
All right. John.
But if these are not shipping, or if these shipping containers are not listed in the bylaw, how can you say that we have to have a waiting period to have a minor variance for something that isn't listed in the bylaw?
I can't answer that. We've got two hands up over there, Ms. Dory and Mr. Fitzgerald. Who wants to try and attempt this one?
Yeah, no, I totally understand where he's coming from. I think the question is more so why do I even need a variance? It's more so the question that's being asked. So I would just counter with permitted use in the bylaw, so you can't get a building permit for it.
Okay. Ms. Story.
And I just want to thank you, John, for going through due process. And unfortunately, the fees would be applicable due to staff capacity and taking it through to council.
All right. Is there anything else before we move on? Nothing? Okay. So at this point, we can close the public meeting. Do I have a mover and seconder for the recommended motion that's appended to your agenda? Councillor Heeman's moving, seconder, Councillor Lockie.
I would like to make the addition though that there is a $1,200 rebate of his fees.
Okay, so you're recommending that the motion would be as per the agenda with the addition and that the application fee of $1,200 be refunded to the applicant. That's the motion you are moving. Are you still in favor of that? Okay, so we have a mover and a seconder. All in favor? None opposed, so that motion carries. Thank you for your presence here, John. I appreciate that. So moving on, a mover and seconder to adjourn the Committee of Adjustment at 5:44 PM. Deputy Mayor Smybert and seconded by Councillor Lockie. All in favor? That motion carries. Thank you. Okay, moving on to delegations. Number 8.1 Firemark Inc. Presentation on indemnification technology program. And we have a guest with us, Mr. Carrier of Firemark, whenever you're ready.
Good evening, your worship and members of council and staff and the audience at home and present as well. As a former mayor of Collingwood, I'm always thrilled to watch other councils in action and I congratulate you on your public participation thus far.
I hope you're not grading us, are you?
No, sir.
Good.
No, ma'am. No. I would never do that after 13 years. No. Firemark began its operations in 2011. Our company was started by a number of semi-retired and retired insurance adjusters. The top two adjusters in our firm have over 70 years of senior claims adjusting experience. So you're talking people that are not in middle management, they are in the upper management section of the adjusting expertise of the insurance industry. Next slide, please. The company was incorporated over 12 years ago. We do have clients coast to coast to coast, and by that I mean we have clients in British Columbia, Alberta, Saskatchewan, Manitoba, which just signed up, and New Brunswick in your bands of the east. We have both Fredericton, St. John, and then also DF has just come on board in New Brunswick. In Ontario, we have over a third of Ontario's departments as clients. We have large urban, small urban, rural townships, local service boards, and we also have one First Nations community, which is Saugeen First Nation Band 29. Next one, please. What we do for you is that we recover expenses that you're entitled to receive, your fire department is entitled to receive in response to an insured peril, of which there are 13, but the most obvious one is a structure fire. Next slide, please. With the wordings for your bylaw that I've provided, it actually unlocks the insurance coverage. If you go home and check your own property policies, you'll see under the additional coverages section, there'll be a fire department expense coverage. The amounts will vary. It could be $1,000, it could be $3,000, $5,000, $10,000. My home in Collingwood, Ontario is insured with Aviva. There's 193 insurers operating in Canada with Aviva, and I actually have unlimited fire department coverage for my home. Next slide, please. The language of the contract is really written in such a way that unless you pass local legislation to unlock that coverage, you're not entitled to receive it. You're at the goodwill of the industry in order to receive any funds from that coverage. And I'm going to suggest that prior to 2010, there was only 2 municipalities in Canada that were invoicing, and it wasn't like the industry was running to your doorstep to hand over money. Almost all property insurance policies have this coverage, so it will depend on the type of property and the coverage. I have seen 2 policies where the coverage was not available, and one of them was actually my in-laws cottage near Chatsworth, Ontario. It was on a road that was not accessible in the wintertime, so the property was insured, but there was no fire department coverage because the fire department couldn't get there. We also have seen a number of insurers increasing the coverage over the last 13 years in business as well. Next slide, please. This is one that I asked you to focus on, much like your budget process. The Insurance Bureau of Canada publishes every year, 2014 onwards, when I've been looking at the fact book, and it tells you how they calculate premiums. So Aviva, as my policy holder, I'm insured and my risk is maintained against their whole portfolio of clients. So it's a shared risk amongst their whole portfolio. But in establishing my premiums, yes, they've projected what their claim costs should be. They've also calculated what their taxes should be and what their operating expenses and expected profits are. And so this is where I ask you to focus, much like your municipal budget. process. If everything stayed the same, we wouldn't have to raise taxes next year. But where you face the pressure is on inflation. And the same with fire department coverage within the insurance premium. The pressure that the industry is seeing is supply chain issues. So the cost to replace a home, the contents, all of those things are subject to inflation. As an example of an insurance carrier in 2014, Cooperators fire department coverage was $5,000. In 2024, it was $5,000. I'm going to go out on a limb and say in 2030, it's going to be $5,000. It's fixed. There is no inflationary pressure on that line item for that insurance coverage. There is no risk for our program causing an increase to any policyholder. Next slide, please. I've gone through this with your chief and some of your staff as well, and they have certainly contacted other departments to ask them about the process, but essentially the process was initialized after an incident occurs. The chief will send us some information and we'll begin our process. Next slide. We confirm that there is coverage. So we're almost guaranteed there is coverage. We have a database of the policy wording. So I'm not going to call up your policy or your constituent and say, I want a copy of your policy. I already have it. Odds are I already have it. I'm not interested in your first 3 or 4 pages of your policy that has your specific personal private information in. It's all of the 30 or 40 or 50 or 60 other pages of that policy. We've got them. We know what the coverages are for the fire department coverage. There is no cost to the property owner. It is deductible exclusionary. So you'll see on most of your policy, you'll have a deductible applied to something. Under the fire department coverage, there is no deductible applied. So the policyholder is not out of any money. We are not asking the policyholder to pay the invoice and then be reimbursed from their insurance company. We are working with the insurance adjuster for Cooperators or Aviva or whomever to recover those funds and return them to your fire service. Some insurers, when I started, there was 234. I just mentioned now there's 193. Some insurers do ask us to copy the information to their policy holder. So depending on the company and depending on the adjuster, we agree with those caveats for them. That's going to make it easier for us to recover for you. In establishing that process, we've worked with a number of fire chiefs across Ontario to ensure that the language is going out, it meets a municipal standard, of course, but also to ensure that the policyholder is not under any misunderstanding that they're expected to pay. Their insurance company is expected to pay. Next slide, please. Here is the more detailed process. After an incident, the chief fills out what they call a standard incident report. We would like a copy of that information, the scene release form, and an initial report form. The initial report form is something that we provide so that our input clerk doesn't have to go through 3 to 30 pages of data. It just gives us a quick summary so that we can set up the file and then it's off to the adjusting team. We pull up the database for I'm going to use Cooperators as an example. For Cooperators, we'll reach out to the adjuster for this area and say, has so-and-so made a claim against the incident that occurred on the property at such and such a date? The answer is yes. Then we piggyback on that claims process. If the answer is no, then we close the file and return it to you. A number of insurers across the country have what they call a no claims discount. So if the policyholder is entitled to a no claims discount by not making a claim in a small incident, then we're not going to harm the policyholder in any way by making a claim when they've not made a claim. The average recovery is 14 weeks. Shortest recovery is 8 days. The longest recovery has been 42 months. So the 42 months was a non-residential fire property. It was actually not that far from here in Ontario. It was a rural township, but we followed that process. And that was a maximum payout policy. So we had to follow that process until the occupancy permits were issued and all the bills were in, but we were still able to recover over $34,000 in firefighting costs for our client. You receive 70% of the funds that we recover. We retain 30% for ourselves. There is no minimum. There is no annual fee. The only time that Firemark receives compensation as if your fire service receives compensation. So that 42-month file that we worked on, or that extended period of time, if we recovered nothing, there was no cost. If the fire chief is unsure that there is coverage, or let's say it's a weird type of incident, and he wants us to investigate it, then we do at no cost to you, unless of course there is a recovery and the property is eligible for insurance coverage and has the coverage. Next slide, please. The money stays, I should mention this, the money does stay within the fire department budget. It doesn't go to municipal general revenues. I've done this presentation for AMCTO with a room full of clerks and treasurers, that I do have the Municipal Act correct. And of course, the 1998 Supreme Court of Canada decision, and then it was expanded upon in 2005, defining the difference between a fee and a tax. So municipalities have limited taxing powers, you have broad fee powers. So if it's a fee for a service or a product, it can stay within the department, but if it goes into general revenues, it's deemed to be an indirect tax, which you could get your wrist slapped by an aggressive insurer or somebody who just wanted to make a name for themselves. Coming here today, I stopped at 5 different municipalities on my way, dropping off checks. So you can see some happy faces there on the slide. It's always fun. As a former mayor, I know how much the fire service could use the funds, especially with inflationary pressures today. And I quite enjoy it to drop those checks off and maybe gossip a little bit about local politics in those communities, because I enjoy that too. Thank you, Your Worship. I'm ready for any questions that you may have.
Thanks, Mr. Carrier. Is Mickey the dog? Show me the Mickey.
Yes,
that
so Your Worship, the president of our company used to volunteer when he was in Calgary with Royal Insurance, he used to volunteer with the local deaf association, and he would take his golden retriever Ducket.
Okay.
Yes, and they gave him Mickey when Mickey was a puppy and Mickey was deaf.
Okay.
So the kids, Ducket and Ted, trained Mickey, and when he passed away when he was 12 and a half, he knew 26 hand signs. So yes, where it's a little exploitative because it's Dalmatian, but there is a video on our website.
Okay. All right. Thank you. All right. Does council have any questions that they'd like to ask of Mr. Carrier? Deputy Mayor Steinberg.
No questions really, just to thank Chris for coming in for the presentation. I've had the opportunity to have worked with Firemark for several years. They are a great company. You do all the work for the administration. The company is just providing the amounts of money that is owed to the municipality that unfortunately the insurance companies aren't passing along. So I think it's a good service, it's a needed service. So thank you.
Thank you. And through Your Worship to the Deputy Mayor, I would like to clarify, there is no legal obligation for your broker to tell you what is in your policy. The legal obligation is for the policyholders to know what their coverages are. And I say that for a real example, North Battleford, Saskatchewan was a client and they had a fire in the library, and their insurer at the time, I don't need to mention, we called them up and said, hey, North Battleford, have you made a claim against your policy? They said, no, how come? We said, because you have $100,000 worth of fire department coverage in your own policy. And they're like, how come nobody told us? Like, we're telling you. So we were able to recover $28,000 in firefighting costs for the municipality from their own insurer, as opposed to the taxpayers of their community.
Great. Okay. Any other questions? Danielle.
Through Your Worship, to Mr. Carrier, just in your opinion, will we be encouraging potential property owners to make claims when at times they might be kind of on the fence in terms of whether it's worthwhile making a claim or not?
Through the mayor to the councillor, no. You'll see that there's a lot of handy folks out there. And if it's a small claim, that they'll do the repairs themselves. And usually they'll have a conversation with their own insurance professional. The broker may have a conversation with them. So that's a discussion that's totally outside of us. We speak to the adjuster, and if a claim has been made, then we piggyback on that claims process.
Okay. And I do have a second question. Now, if all municipalities are using this program, do we think there's any risk that the insurance companies are going to increase their fees to their customers to recover the cost of your service?
Through the mayor to the councillor, no. All indicators are no, and math. So this is an awkward thing for me to say. people lie. Math does not. Every aspect of looking at math, and it's easier to pull the financial statements for small insurers, see what's underwritten, how much has been paid out, and then I can compare how many of those files were fire mark files. So as an example, the ones that I've looked at are 0.029 or 0.028 of 1% and represent 11 cents a policy holder for those smaller mutual firms, because I can do the math quite easily. So no, there is absolutely no risk that they're going to change. And what we have seen, and we've tested the market ourselves, is by adding coverage. So I have standard set of coverage for my property. I want to add another $10,000 worth of fire department coverage. That bill has come in anywhere between $1.90 to $2 and $3.40 per thousand of coverage. So it's not an expensive portion of the policy.
Okay. And will we be entering like a contract for a specific time?
Through the mayor to the councillor, yes, and your staff do have that. And so that I have to demonstrate to the insurance industry that I have the authority to work on your behalf. Otherwise, I'll get this from them. This is go away, leave me alone. So yes, we have to demonstrate that within the contract. I don't know the section off by heart, but there is a 30-day cancellation notice. So we would need a resolution that was provided by the clerk or deputy clerk to us. The council no longer wishes our services, and the 30 days just gives us the process to disentangle ourselves from any process that we are in at the time.
So how long is the contract?
We ask for 5 years. So of our, let's say 170 clients, more than 2/3 are 5 years and some are 3 years.
Thank you. I have no other questions.
Thank you. Any other questions from council?
Through
Councillor
you,
Heeman.
Your worship, we have a lot of calls to the 401. I was just wondering if there's any claims that could be made in that respect. And on a separate note, we have a lot of calls dropped on the way. But again, I think that might be a particular nuance to dealing with the provincial government.
Through the mayor to the councillor, it's so fun dealing with the province when it comes to money. So currently under the MTO program, you can send them a bill for a certain amount of time, response times, truck or 2 trucks, and then the number of personnel, and then you get reimbursed for that. I think that is actually woefully inadequate. OSM and AMO and OGRA and all of the associations should be working with the province to lobby for a more specific study so that they know what your true costs are, so that you are reimbursed for your true costs, not for them telling you what they'll give you. So that's the former elected official in me that feels that you're still treated unfairly, though if you talk to somebody from MTO, they go, "It's a great program." Sure it is for them. Thank you.
Thank you. I noticed the deputy mayor is furiously writing this down. Are there any other questions or comments before we move on? Okay. Then at this point, a mover and a seconder to receive the report from Mr. Carrier. Deputy Mayor Smybert and Councillor Lockie, all in favor? So with your consensus, we'll move on to the item immediately below 11.1 on your agenda. And we're going to ask the fire chief to present.
Thank you, Your Worship, and through you to the members of council as well. The fire department is recommending that receive the presentation as we did, and that council approve entering into an agreement with Firemark Inc. for cost recovery with respect to the fire department's specific responses.
Thanks, Chief.
And that staff bring forward the necessary bylaws at the next regular council meeting in order to implement this with the agreement.
Thanks. Any other questions? Yeah.
I have a comment. I have some concern about entering a 5-year contract, especially if we'll go into the next term of council. So I would like to make the recommendation to just sign a 3-year contract.
Any other questions or comments from council? Okay. Allow me to just check with the clerk for a moment, please. So then the slightly amended to your agenda, that the council approve entering into a 3-year agreement with Firemark Inc. for cost recovery with respect to fire department specific responses, and that staff bring forward the necessary bylaws at the next regular council meeting to implement this. A mover and a seconder. Okay, moved by Councillor Heeman and seconded by Deputy Mayor Smyber. All in favor? No one opposed? Oh, is it moot? Okay, I was talking about the amendment. Okay, then let's change that. It would be Councillor Lockie and Deputy Mayor Councillor Heeman. All right. Okay, are we good? Okay. Thank you very much. All right, moving on to item number 9, the adoption of the minutes from the council meeting of July 15th. Mover and a seconder that the minutes of the regular meeting held on July 15th be approved as circulated. Deputy Mayor Smyber and Councillor Crockett, all in favor? Okay, that's carried. Item number 10 is the consent agenda. Items listed under the consent agenda are received for information in one motion. Council members may request that one or more items be separated for further action. Anything that anyone would like to pull at this time? Councillor Crockett. All right, okay. So at this point then, before we move on to those, ask council for a mover and seconder for items 10.1 and 10.2, and then 10.4 and 5, and then 10.7 inclusive to 10.13. A mover and a seconder. Councillor Lockie, seconded by Deputy Mayor Smyber. All in favor? Okay, that carries. All right, 10.3.
Thank you, Your Worship. I think this will likely be a question for Dan or Alana in regards to 10.3. Just a clarification that when referencing the passing of development charges, are these county charges now added on to our Thames Center development charges, rolled into both? I don't know, you're nodding at both.
Yeah, so through the chair, that's absolutely correct. So it gets added on to your existing development charge.
Certainly, go ahead.
Thank you, Mayor, through as well to the councillor. The municipality locally would be collecting on behalf of the county. So it wouldn't be added on to Thames Centers. It would be just, we would be simply collecting it on behalf of the county.
And I believe that starts January 1, is it not? Yes, okay. Amanda, did you have something further to say? Oh, okay. Darn it, we're reading minds here tonight. Any other questions or comments regarding that? Anything else?
Not on that one.
Okay, all righty. Do you want to move down to item number 10.6 then?
Yes, and I might be putting Councillor Heeman on the spot here, but I was just wondering if reversing the freeze for the Thames Center, or sorry, the Upper Thames River Conservation Area, would this impact that's been set, does it like increase or reduce the fee or levy owed to them? Because I recall last year when they came forward at budget time, there was a significant increase that we gave that organization. So I was just wondering if you had any additional insight on that.
Yes, through your worship, thank you, Councillor Crockett. I'd refer to staff in terms of what the exact increase on the levy was for how it impacted our tax increase, but I think it was like 0.25% or 0.5%. It was a substantial amount in terms of our overall tax levy at Thames Center. Part of that increase was due to new assessment, but another part was due to the increase in the levy due to increased budget requirements to meet provincial timelines without having the ability to collect fees for planning services. So that's where this request is coming from in the event of a lack of recovery for those costs, then those costs are borne by the levy in terms of category 1 services provided by conservation authorities. This is subject to the budgetary process, but I think there's two sides of it. I think there's ways to cut costs in delivering fees. However, with the new provincial timelines and restrictions in terms of reviewing applications, that also puts a limit on the conservation authority in terms of if they don't respond in a timely manner, we get the consequences as municipalities in having to remit application fees. So there's a double squeeze. And up until this point, the response by the conservation authority has been to staff up to meet those deadlines. And the result is a higher cost borne on the levy. So this would potentially alleviate that. And we have had delegations from the London and Area Developers Association saying that they're not opposed to fees for service as long as they are actually seeing service. And I don't think that's an unfair statement from what they said. But again, it's it's a complicated subject, but I think it would development should pay for development.
Agreed. Thank you for that.
Thank you, Council. So at this point, I'm going to turn item number 10.6 over to the clerk to if we're going to go forward on anything on this particular item.
If you guys wish to support it, we have a draft resolution. If you don't, we'll just need a resolution to receive and file 10.3 and 10.6.
What's council's opinion?
I think we should support 10.6.
Okay, all right then. Seconder? Okay, Councillor Lockie? All right, all in favor? Okay, that passes and then.
Would you like me to?
Yes.
read
Yes.
it?
No, let's just,
So that the Thames Center Council support the requested initiative by the Upper Thames River Conservation Authority with respect to revising the decision of the Minister of Natural Resources and Forestry of Ontario, Braden Smith, to freeze the fees conservation authorities can charge regarding planning, development, and permitted fees, and that the mayor be authorized to sign a letter of support prepared on behalf of the elected leaders of the municipalities for the Upper Thames River watershed.
okay,
And that item 10.3 be received and filed.
all right. Do we need to go back through this since I mean,
Nope, I just need a mover and a second.
okay, a mover into seconder then. Deputy Mayor Smyber and Councillor Crockett, all in favor. Thank you. The motion carries. That's why Janice's pay grade is higher than mine. Okay, so let's move on to item number 11, reports of department. First one is the drainage superintendent. PWDR 006-24 Gladstone Drain, request for improvement and drainage works.
Thank you, Your Worship. Good evening, councillors. Give a brief background of the situation here. The requesting landowner is historically takes a lot of water to their property from the property, the farmland that they back onto. The slope of the land does drain towards this property. There is an existing municipal drain in this area. On larger rain events, this drain is not adequate at its current design. And the property owner has suffered property damage because of some strong rain events. So in this case, the owner has requested to improve the existing drainage works as well as requesting further drainage works to try and capture that water that's coming off the farmland behind their property in order to prevent that from causing any further damages. We'll leave it there for any questions. Thank you.
Thanks, Travis. Any questions from council on the issue? Councillor Crockett?
Thank you, Your Worship. It's not necessarily a question, but just a comment to Travis for thank you for speaking with this resident. I know that I've been having a conversation pretty much consistently every time it rains with this gentleman. So I'm glad that we're kind of seeing some progress on this. Thanks.
Thanks. Any other questions or comments? Okay, you have a motion appended to your agenda that the report be received and it's received and adopted, and Mr. DeVos be appointed as the engineer. A mover and a seconder for that motion. Deputy Mayor Smybert, and seconded by Councillor Crockett. All in favor? Okay, that motion carries. Thank you. And you have another one here, the Ralston Drain. Ready? Did I miss one? I'm sorry, we're here. Okay, sorry. Sorry, I moved down. The MacGuffin Drain, I'm sorry.
Problem. The MacGuffin drain, this requesting owner is looking to develop a portion of land at Thorndale and Nizuri. This section of property is not currently inside the watershed of the existing MacGuffin drain. The developer's engineer believes that this area can be drained to the MacGuffin drain. Appointing an engineer, third-party engineer to this will determine that this drain will not be pushed over capacity, as well as assess this land if they are accepted into the watershed appropriately under that report. I can answer any questions from here.
Thanks, Chad. Any questions from council on this particular one? None? Okay. Then a mover and a seconder for the motion as appended regarding the MacGuffin drain. Councillor Lockie and seconded by Councillor Heeman. All in favor? That carries. Okay, Travis, now you can move on to Ralston Drain. Sorry about that.
No problem. So this, the Ralston drain, we have received 3 requests for improvement, 3 different owners along a stretch of land through this section. One owner, being the most downstream, has actually suffered some property damage from some pretty extreme rain events that we've experienced this summer. The owners are looking and hoping that we can use the Drainage Act to deepen and widen the ditch so that these problems will be addressed through a new report, as the existing reports are quite dated, one of them going back to 1910. So hopefully an update can help the owners in this area, and I can answer any questions from there.
Okay, any questions from council? Yeah. Deputy Mayor Smybert?
Again, not a question, but thanks so much for looking after this. I know that has been quite a concern for some of the property owners there, so I appreciate your quick action on it.
Okay. A mover and a seconder for the motion if there's no other. Moved by Deputy Mayor Smybert and seconded by Councillor Crockett. All in favor? Thank you. The motion carries. All right. So, thank you, Travis. So 11.5 on your agenda, application for part lot control exemption. PLC 3-24 975009 Ontario Limited, operating as the Willows Golf and CC Tonda applicant. Development Engineering London Limited, care of Sean Duncan as the agent. And the properties is 34 and 38 Gulf Drive, Willows subdivision in Nilestown. Whenever you're ready, Alana.
Thank you, Your Worship, through you. So the purpose of this application is to exempt certain lands from the Planning Act provisions with respect to part lot control to allow the further subdivision of the lands to expand the frontage for the Willows Golf Course by reducing the frontage of lots 5 and 6 on Plan 33M834. So the subject properties are situated on the south side of Gulf Drive and east of Westchester Bourne, located in Nilestown as part of the Willows subdivision. The applicant is seeking to expand the frontage of the Willows Golf Course from 4.698 meters to 8.218 meters by reducing the frontages of lots 5 and 6 from 32.24 meters to 30.48 meters. And to allow for this change to the lotting and frontage, the applicant is requesting an exemption from part lot control. So the provincial policy statement, county and municipal official plans encourage intensification in settlement areas, provided the development is compatible with the surrounding area and represents an orderly and efficient use of land and infrastructure. Within the designated hamlet of Nilestown, development opportunities are limited to infilling of the existing development pattern. If appropriate, private servicing can be achieved in the absence of full municipal services. In this case, the request for part lot control exemption seeks to adjust the sizes of the two existing lots to increase the size of the frontage for the neighboring golf course. No new lots would be created. So the proposed lotting would ensure conformity with the requirements of the hamlet residential zone. So although there's no legislative requirement for public or agency consultation for part lot control exemptions, municipal departments identified no concerns. And to avoid subsequent transfers without a Planning Act consent, part lot control exemption would expire in 1 year. As the subject application meets the requirements for part lot control exemption and is consistent with the planning framework, it is respectfully recommended that the requested bylaw be approved. So staff recommend that that application for part lot control exemption PLC 3-24 be approved and that the adopted bylaw be forwarded to the County of Middlesex for consideration for approval. Thank you.
Thank you, Alana. Any questions from council on this one? Councillor Crockett.
Thank you, Your Worship. Again, not a question. But in previous correspondence with a neighbor in this area, I would just like to put forward that when you're having conversations with the applicant and the agent, can you request that they give the neighbors a heads up before construction begins? I know that there was some concerns regarding the kind of back shop laneway area running along the residential properties. So thank you.
Any other questions or comments? No? So the motion before us is appended to your agenda, and do I have a mover for the recommended motion as appended to the agenda to approve this part lot control exemption application? Moved by Councillor Crockett and seconded by Councillor Lockie. All in favor? Motion carries. Thank you. The next one is 11.6 PDS -046-24, application for Housing Accelerator Fund HAF2. Ms. Dory, when you're ready.
Thank you. Through you, Your Worship. This report provides an overview of the second round of a federal housing initiative to provide financial support to local governments and to inform council on the municipality's proposed Housing Accelerator Fund submission to the CMHC. The initiatives outlined in our application are a part of the 10 HAF2 best practices. And I should caution that the The initiatives in the report are proposed to be explored if we do receive the funding. They're not set in stone. They are to explore if they are best suited for the municipality and to be brought back for further discussion and consultation. The 10 initiatives would be end exclusionary zoning by increasing as of right permissions, including 4 units as of right in low density neighborhoods, and greater density and height in urban cores near transit and near post-secondary institutions. Leverage surplus and underused lands for housing, increase process efficiency through e-permitting, streamlining reviews and new digital tools, fast track approvals for affordable housing and purpose-built rentals, review fees and charges, including waivers for affordable housing, reduce or eliminate parking requirements, eliminate restrictions to promote housing diversity and supply, develop or enhance affordable housing community improvement plans, introduce design guidelines and pre-reviewed building plans for accessory dwelling units and missing middle housing, implement grant and incentive programs for priority housing types. So below in the comments section, you'll see we have chosen 7 out of the 10. So that being end exclusionary zoning, eliminate restrictions related to height, setbacks, building floor area, and others to allow greater variety of housing types, develop affordable housing, community improvement plans or strategies for the rapid development of affordable housing, increase process efficiency, reduce or eliminate parking standards to increase project viability, density, and reduce carbon footprint, design and implement guidelines or pre-approved building plans, and develop grant programs. With the review of the report, I'm here to answer any questions you may have.
Thank you, Amanda. Any questions? Councillor Crockett.
Thank you, Your Worship. And thank you, Amanda, for the clarification. I think when I first read this report, I was a little worried that these initiatives were committed to and not just as a defined outcome, as you mentioned here. I think just to highlight for those that had the same understanding, if someone read the agenda. I don't know, Marcel, did you read the whole agenda? Okay. I think in particular, my concerns revolved around item 1, which was, sorry, now I'm trying to find my email so I don't have to pull up the report again, which was in regards to low density housing. I think a notion that we mention often here in council chambers is maintaining the look and feel of the municipality. And although we do want to diversify our housing stock, low density units seem to still be the ones that are preferred in this area. The second was just my concerns around the height restrictions. I know that we've had a number of conversations regarding our fire department's ability to handle fighting fires in buildings above 4 stories. And then the third being a popular topic tonight, but in regards to parking accessibility throughout the municipality. So thank you for that. And I mean, I don't think we should ever turn down money that's forthcoming. So all the best.
Any other questions or comments from council on this item? Tom?
I'm just curious, you mentioned that this is like in consultation and collaboration. So like what criteria do we have to fulfill in order to receive funding?
So this application is to choose those initiatives that you would prove that you could explore for the municipality. So if it's best suited for a zoning bylaw comprehensive review, we will implement it in the best way that we can see fit holistically in the municipality. So we don't have to commit to any of these initiatives, but if we receive funding for them, to my knowledge, that funding can be used for those explored initiatives.
So the funding can only be used for the items outlined.
Yes.
Okay.
Another piece of the application did ask about capital projects, if we weren't able to explore those options, in which we've mentioned the capital project ongoing. So it's not just limited to if we can explore those options for our municipality.
Anyone else? I had the same sort of concerns that Chantel has expressed, and I had extensive conversation with Amanda prior to the meeting. I'm reasonably satisfied that if we can go ahead and plan for the or go ahead with the grant application, because like Chantel says, it's handy to have some more money coming in. However, I think there are some significant points in here that we have to consider should we get that funding that would apply directly to our municipality and our strategic plan.
Through your worship, would an official plan review be an eligible expense?
Unsure. However, I think a lot of these initiatives have, sorry, through you, your worship, would have to undergo a comprehensive zoning bylaw review. The official plan might be in that mix, but we just underwent an official plan, so I don't foresee that being in the near future.
Mr. Fitzgerald, did you want to add something?
Yeah, so through the chair, like what I would say is you're not going to use the funding towards your growth studies to implement your official plan objectives or amendments or comprehensive reviews. What the funding is really for is to help unlock potential growth within the municipality specific to housing. So the initiatives that the province has identified and the county gave a list, and then you've got 7 before you that you're looking at now. Those are the initiatives that you're going to work towards implementing to help unlock that additional housing supply within your municipality. So it's not necessarily to be used for the official plan process, but maybe there's support that needs to happen in order to achieve some sort of additional density unlocking within the municipality. So it goes as far as saying you could use it towards hiring staff or infrastructure projects or zoning bylaw amendment updates. Part of it talks about the fact that a big part of it, and we saw it with the half one funding, was basically municipalities committing to a minimum of 4 units as of right. That's kind of the theme that we're hearing moving forward. So that would encapsulate us going and opening up the zoning bylaw amendment, doing a comprehensive review of that, implementing those policies. That would be just like a small example of things that are initiatives that you would use to get that funding to be able to reallocate to different services within the municipality. We're not exactly sure that it's specifically tied to those initiatives. It could be used elsewhere, but you have to show the link between the two.
Thank you. And that was my understanding coming into this meeting. Is there anyone else wishing to comment? Deputy Mayor Smyberg?
Yeah, just a question. One of the criteria is having a current housing needs assessment report. They consider that to be an asset. Are we able to kind of tie into the County of Middlesex's housing strategy? Okay, that's perfect. Thank you.
All right. Any other questions on this regard? Okay. Seeing none then, we have a recommended motion before us to endorse this housing accelerator fund application and to forward this resolution on to the office of MPP Karen Vecchio. A mover and a seconder. Moved by Deputy Mayor Smybert and seconded by Councillor Crockett. All in favor? Motion carries. Thank you. All right. 11.7, Thames Center Senior Center Advisory Committee name change. So the clerk is presenting this one.
Oops, sorry,
Deputy Clerk. There you go.
Thank you, Your Worship. I'm here to present report number LS-010-24, which is an update for council regarding the name change for the Thames Center Senior Center Advisory Committee.
So back at the council meeting held on May 13th, there was a report regarding the name change of the Lions Senior Center to the Lions Active Living Center. So because of this name change now, it makes sense to change the name of the committee as well to the Active Living Center Advisory Committee. So attached to this report, you'll see the updated terms of reference. And if you have any questions, I'm happy to answer them.
Thanks, Sarah. Does anyone have any questions regarding this? I sure like active agers as opposed to seniors. Do I have a mover and a seconder then as well? Moved by Deputy Mayor Smybert and seconded by Councillor Lockie. All in favor? Thank you, that carries. The next one is 11.8, proposed amendment to the animal control bylaw. So I'm going to ask our clerk to go with this one.
So I'm presenting LS 1124. It is the draft amendment to the animal control bylaw that has been precipitated by this rezoning for the new addition of the doggy daycare. We currently have other dog daycare facilities within the municipality that annually get kennel licenses, and by amending the animal care bylaw or animal control bylaw to add this additional license would just bring everybody on the same playing field. It's set to come into force and effect in the 2025, as we generally send out notices in the beginning of October as a reminder for everyone to get their licenses before the end of December. We also did a little bit of minor updates to the animal control bylaw to clarify some parts. Staff are preparing to do a comprehensive review of the animal control bylaw in early 2025. But this was just some items that needed to be tidied up before we got too far. So if you have any questions, I'm here to answer them.
Any questions for the clerk? Okay. In that particular case, do I have a mover for the recommended motion as appended to the agenda to approve the draft amendment to the animal control bylaw? Moved by Councillor Heeman and seconded by Councillor Lockie. All in favor? Thank you. Motion carried. Thank you for that, Jana. Reports of committees. Item number 12. Items listed under the reports of committees are approved by council in one motion. Council members may request that one or more items be separated for further action. So the motion would be that reports of committees, agenda items 12.1 through 12.3 be approved as presented. A mover and a seconder. Councillor Heeman and Councillor Crockett, all in favor? Thank you. That carries. Okay, on to the mayor's report. With the summer pretty much behind us, commitments slowing down over the warmer months, and one less meeting in August, the report of my various activities since my last report in June is quite a bit reduced. July and August saw meetings of Middlesex County and a meeting of the Community Schools Alliance via Zoom in mid-August. On August the 18th, I, along with Deputy Mayor and CAO, traveled to Ottawa to attend the 2024 Association of Municipalities of Ontario, otherwise known as AMO. These conferences give member municipalities the opportunity to meet personally with ministers and staff on some of the more important issues in their communities. This year, we were pleased to meet with the Minister of Energy, the Minister of Tourism, Culture and Gaming, along with the Ministry of Infrastructure. As part of my membership in SCORE, South Central Ontario Region Economic Development, I participated in delegations to the Minister of Agriculture, Food and Agribusiness, as well as the Minister of Economic Development, Job Creation and Trade. On August the 22nd, I attended a regularly scheduled meeting of the Kettle Creek Conservation Authority Board in Elgin County, followed by a meeting of the SCORE Board in Tillsonburg. On Thursday evening of this past week, I was very pleased to attend the AGM of the Middlesex Farmers Association, where I had lots of opportunities to learn about some local and provincial matters, along with a really informative address by Christine Brown on all matters manure. And I came out of there thinking, who knew how interesting manure could be? Anyway, it was very good. I learned so much. Don't ask me to tell you and pass it on, but It was great. On Friday evening, I was happy to be invited to join with MP Karen Vecchio, MPP Rob Flack at the Optimus Club of North Dorchester to celebrate the award of a $29,000 Trillium grant for improvements to the club facility, a whole new exterior paint job, and 2 badly needed furnaces. The Optimus Club does some really great work with the youth of our community, as well as providing space for many, many events taking place in Thames Center. And I offer council's sincere gratitude for the work and dedication of that group. Excuse me. Saturday and all its iffy weather saw the first ever Corn Fest and the corn husking contest. Sadly, I was a loser, but kudos to Chief Nick Dorkin for taking part, and especially to the winner, our very own councillor, Chantel Crockett. So I think we're going to have to step up our game next year, Nick. Okay, that's my report. Any unfinished business? Notices of motion? Any new business? Okay, seeing none, moving on to item number 17 for the bylaws. Mover and a seconder that bylaws 59-2024 and 6024 be adopted as presented. Tom and Chantal. All in favor? Motion carried. Thanks very much. All right. A resolution to move into closed session that council adjourned to closed session at 6:41 PM pursuant to section 239 bracket 2 bracket E and F of Municipal Act 2001 in order for council to consider matters that involve litigation, potential litigation, including matters before administrative tribunals affecting the municipality and advice that is subject to solicitor-client privilege, including communications necessary for that purpose. I'll move right into second. Deputy Mayor Smybert and Councillor Crockett, all in favor? Thank you. That motion is carried, and we'll take